Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-immigration. Ever feel like you're using 5 different tools just to get one case out the door? If your tech stack is stressing you out, or worse, slowing you down, it's time for a different approach. The podcast recommends checking out e-immigration's Immigration Software Buyer's Guide. It breaks down the signs that you've outgrown your current system, what to look for in a new one, and how to make the smoothest switch. Get the guide at get.eimmigration.com/resources to make smarter software moves in the new year, or click on the special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Kilmer Abrego Garcia is back in the news. This time being ordered released from immigration detention by a federal judge, indefinitely it appears, and based in part on the fact that it seems he was never actually ordered removed in the first place. Incredible. Incredible the unnecessary cruelty of this case. And yeah, if an immigration judge granted withholding of removal but never first actually ordered Mr. Abrego Garcia removed, the IJ kind of messed up. And I do feel a bit for the IJ. But also the rules are the rules, as the BIA reminds us every week. What else we got? I don't know, so much. Some very important oral arguments occurred in the 11th Circuit this week, including but not limited to one that I was on. And one way or another, we're going to have a couple of important 11th Circuit decisions next year. Fingers crossed for non-citizen good. Other than that, in personal news, I'll be out for the rest of the year starting next Friday. I'll be doing some of the cases next week too, but steady hand Elizabeth Montano from KKTP will be taking the reins through 2026. As such, I want to say thank you now to everyone who has supported the show on Patreon or otherwise this year, to anyone who has reached out to me, and to everyone who listens and finds value from this labor of love. The pod is a lot, but it also brings me great joy and gives me a bit of a voice, and I'm very humbled by that. I try to use it for good. I'm also going to try to take these next few weeks to recharge for 2026, because while I don't know what's coming, I know something is. I doubt I'll truly succeed at recharging, but I'm going to try, and we should all do the same. Immigration needs us now more than ever. To everyone who's been in the fight this year, I tip my hat to you. To all the fired and forced out immigration judges, attorney advisors, and other federal employees everywhere, you have my support, and the immigration bar and the majority of the United States population has your back. To anyone who had a rough year, a new one's coming up. See you all in 2026. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. Our first case, because why not, is Osabas-Rivera v. Bondi, published by the 6th Circuit on December 8th, 2025. This case is about untimely asylum applications. Not recommended! Mr. Osabas-Rivera is from Honduras and fled the MS-13 gang in that country. They were targeting him and his brother, as I understand that they target so many people. Apparently, MS-13 infiltrates soccer clubs in Honduras and recruits and threatens people inside it. After some time of threats and extortion, MS-13 actually kidnapped Mr. Osabas-Rivera for 4 hours in 2013. Quote, gang members beat him, cut his cheekbone and eyebrow, pointed guns at his head, hit him in the back of the head with the butt of the gun, end quote. They were retaliating against him and also searching for his brother. He fled in fear for his life. He reported what happened to him, but it only made matters worse, and MS-13 began texting him, telling him that they knew that he moved and that they knew what his new town was. They said they'd kill him. Pretty clear police had leaked what he reported, but Mr. Osabas-Rivera technically has no proof. He fled to a new town after a few years of threats and then to the United States, leaving his family behind, although they joined him in the United States in 2019. He believes that the MS-13 gang is still looking for him. But you see, Mr. Osabas-Rivera's non-detained removal proceedings occurred kinda slowly, and by the time he was really and directly warned about filing for asylum, it was already June 2017, 8 months after his entry. An immigration judge specifically told him that he had until October 22nd, 2017 to file. Mr. Osabas-Rivera, however, either didn't have the money or didn't act with haste, and he didn't hire an attorney until July 2018. So by that point, he was in trouble. The attorney managed to get it filed by December 2018, but that's 14 months after the arbitrary congressionally imposed 1-year deadline. At his final removal hearing, Mr. Osabas-Rivera explained that he was very depressed and wasn't taking sufficient action until he got less depressed with his family's arrival in the United States. He was very upset being separated from his family. The IG deemed that insufficient exceptional circumstances to justify a delay in filing an asylum application and so outright denied asylum. Withholding of removal and Convention Against Torture Protection denied on the merits, and the BIA affirmed. And well, the 6th Circuit held that it lacked jurisdiction over the timeliness issue, as a few circuits have now done before it. I could be wrong, but I believe a separate statute bars review of pure factual issues tethered to the timeliness of asylum applications. In any event, the 6th Circuit held that its prior precedent on this barred it from reviewing. For example, the IJ and the BIA's alleged minimizing of the severity of Mr. Osabas-Rivera's depression. 6th Circuit already has case law on that. Can't review that factual issue. Nevertheless, assuming the fact, that is the depression, doesn't meet the extraordinary circumstances standard required to accept the 1-year bar to filing an asylum application, that extraordinary circumstances stood in Mr. Osabas-Rivera's way? That's a mixed question of law and fact, after all, and those are all the rage these days. Well, no, said the panel, can't be reviewed. At least here. Not enough. Not enough law. First to the regulations themselves. They give examples of what constitutes extraordinary circumstances, quote, serious illness or mental physical disability, end quote. And even then, the regulations require that an applicant file his asylum application, quote, within a reasonable period of time, given those changed circumstances, end quote. Now, after Guerrero-Lasprilla, the 6th Circuit did apparently hold in an unpublished opinion that it can review whether a non-citizen, quote, filed his asylum application within a reasonable period of time, given the circumstances based on the undisputed facts of his case, end quote. I guess that's a sufficiently legal question? And the court's treatment of that unpublished opinion here in this published one is certainly something I'd cite to in the future in the 6th Circuit if you're seeking a review of that specific issue. The issue here, however, is not that to the court. The issue here is governed by another portion of the statute about extraordinary circumstances, which has a qualifier that all of this must be to the, quote, satisfaction, end quote, of the Attorney General. As the 3rd, 7th, 8th, 10th, and 11th circuits have held to various degrees according to the panel, that just makes it all too discretionary and malleable for a circuit to review. Most recently, that's the 11th Circuit in their APA v. U.S. Attorney General decision, episode 215, the only post-Wilkinson decision, I believe. Da, 11th Circuit, da, I say. Plus, the 6th Circuit said something very similar in its Rahman decision with a 212I hardship waiver on episode 255, so there's that. It all kills review to the court. To the satisfaction of the Attorney General, strikes again. She will never be satisfied. Alexander Hamilton sympathizes, and the 6th Circuit won't review the issue. On to withholding of removal then, no time limit there, but of course harder to get, and, in this second coming of Trump, very dangerous to simply rely on. Well, apparently Mr. Osabas-Rivera missed an element in his brief to the BIA, didn't really challenge the IJ's finding that the Honduran government was willing or able to protect him. Oil caught that, as it is apt to do, and challenged the omission, meaning that to the panel, Mr. Osabas-Rivera failed to exhaust that issue. Meaning he can't challenge it now. Meaning he's missing a withholding of removal element to challenge a review, no matter the persuasiveness in his other withholding challenges. Meaning that he did not succeed here. And that is Osabas-Rivera v. Bondi. Join me on a beautiful journey of 4 BIA decisions, won't you? First, matter of Jimenez-Ayala, published by the BIA. This case is about discretionary reliefs. The Attorney General decided to make it precedential because she loves it so much. Miss Jimenez-Ayala has been a lawful permanent resident for over 25 years. But she committed a crime that made her removable, which was abandoning or endangering a child, in violation of Section 22.041F of the Texas Penal Code. An immigration judge granted Ms. Jimenez-Ayala LPR cancellation of removal, gave her a second chance. DHS appealed because why not, and the BIA sustained the appeal and ordered Ms. Jimenez-Ayala removed to Mexico and away from her U.S. citizen children. Why, you ask? Well, everyone agrees that Ms. Jimenez-Ayala is eligible for this second chance for the release. The only question is whether she deserves a second chance as a matter of discretion. The IJ fact finder that heard testimony and assessed credibility and remorse believed that she did. The BIA weighed that evidence differently, allegedly. And that is why she's being ordered removed. Discretion requires a balancing of positive and negative factors, you see. Quote, favorable factors to be considered include family ties in the U.S., residence of long duration in the U.S., particularly when the inception of residence occurred at a young age, evidence of hardship to the respondent and her family if removal occurs, military service in the U.S., a history of employment, the existence of property or business ties, evidence of value and service to the community, proof of genuine rehabilitation of a criminal record exists, and other evidence of the respondent's good character, end quote. So really everything, but a good quote to remember. Here, Ms. Jimenez-Ayala has lived in the United States since she was a baby. So literally, this could be any one of us natural U.S.-born citizens. If that birth certificate you and I rely on so much actually turns out one day to be mistaken. So not really a second chance at all then, right? Ms. Jimenez-Ayala didn't immigrate here willingly. She is part of our community. But such arbitrary distinctions have big consequences, and immigration law treats Ms. Jimenez-Ayala the same as any lawful permanent resident that came to America in, say, her 40s and, say, 7 years ago, for example. Her parents and family are U.S. citizens and LPRs, and they testified at her hearing. Seems like Ms. Jimenez-Ayala developed a bit of a drug problem growing up in America and has been attending rehab to address it since her arrest in 2021. She relapsed, though, in 2024, probably because she's addicted to drugs that she came into contact with growing up in America, and she attended mandatory classes to address that relapse as well. She's also becoming religious and reads the Bible to level herself. Quote, she feels as if her children being taken away from her has opened her eyes. The respondent has been apologetic and remorseful for her conduct, end quote. Seems like the BIA accepts this. Yet, explained the board, it is in the interest of the United States to deport this woman. She's been using meth since 2014 and used it while pregnant because she's addicted. Put her children in serious danger both in utero and after birth because of it, no doubt, and because she was an addict. Unlike the IJ, the BIA refuses to forgive the fact that Ms. Jimenez-Ayala got addicted to meth and did dangerous things because of it, and really, to me, a lot of this depends on that 2024 relapse. Seems to be the crux of it, to me at least. Quote, although we believe the respondent genuinely hopes to change, the evidence is insufficient to demonstrate that she has been rehabilitated or that she will refrain from conduct that endangers others, particularly her children, who have already tested positive for drugs or been present when she used them. End quote. Exceptionally difficult stuff and exceptionally harsh ruling, in my opinion. But I truly believe the case distinguishable from your similar case, provided that your client doesn't have a recent relapse. And I do pray that no BIA member ever suffers the pains of becoming addicted to something. The BIA also doesn't appear entirely convinced that Ms. Jimenez-Ayala has truly committed to turning her life around. Which, given these quotes and what the IJ found, is getting awfully close to impermissible fact-finding to me, despite how the BIA is couching what it's doing. Given its belief, though, that Ms. Jimenez-Ayala has insufficiently rehabilitated herself, and, of course, given the presence of meth in her past, the BIA has effectively banished Ms. Jimenez-Ayala from the United States forever. And that is matter of Jimenez-Ayala. Next is matter of WF, published by the BIA. This case is about Convention Against Torture Protection. The Attorney General decided to make it precedential because she loves it so much. An immigration judge granted Mr. WF cat protection. The BIA reversed to ensure that Mr. WF is removed to Haiti. Mr. WF was actually admitted as an asylee in 2007 and became a lawful permanent resident in 2008. But he messed up and was convicted of carjacking in 2023 in violation of 18 U.S.C. Section 2119. The IJ granted cat deferral based on a finding, it appears, that it was more likely than not that he'd be tortured in a Haitian prison and the gangs that essentially run that country upon his return. But the BIA has disagreed here, and the Attorney General made it precedential. Really focusing on the Haitians this presidential term. Before getting there, the BIA applied matter of NAM to agree that Mr. WF's crime was indeed a particularly serious one that made him ineligible for everything except cat deferral. Under that decision, IJs can consider whether the facts of a conviction make it a particularly serious one, quote, once the elements of the offense are examined and found to potentially bring the offense within the ambit of a particularly serious crime, end quote. There's that first step analysis the BIA appears to be explaining. Here, Mr. WF didn't contest that the elements of the offense made it particularly serious, so the BIA didn't conduct that initial analysis. He instead argued that considering his mental health, his specific crime wasn't particularly serious because it didn't indicate that he will be a danger to the community. A completely proper consideration under matter of BZR, pretty much the only Attorney General decision of substance issued by Attorney General Garland. Still exists. However, explains the BIA, the IJ found that Mr. WF intended to commit the crime. I suppose notwithstanding Mr. WF's mental health? Unclear, but I guess that's what the BIA is implying the IJ found. And even so, quite the narrow scope of the relevance of mental health evidence that I don't believe matter of BZR so narrowed. But, as a particularly serious crime, we're on to cat deferral. The BIA reversed the IJ, applying Third Circuit law as I imagine was required. First, the BIA found no clear error in the finding that Mr. WF will more likely than not be detained immediately upon his return to Haiti. So we're assuming he ends up in a Haitian prison. But here we go, quote, poor prison conditions and indefinite detention without more do not constitute torture, end quote. And LOL, adding indefinite to that standard now? Like detention forever without legal basis will not be torture to the BIA? Is that what the BIA's quote means? These BIA members are hardier than me, I'll give them that. Now, quote, expert witness Brian Concannon testified that criminal deportees are often held in prison and tortured until a bribe is paid, end quote. I know Brian Concannon. He may truly be the most expert of all experts on Haiti in America. Look him up. The BIA didn't believe this part of his expert testimony, as framed in this decision, though, sufficient. Quote, though Mr. Concannon attested to the frequency of this practice. Anecdotal reports of bribery in Haitian prisons is not sufficient to show that it is more likely than not that the respondent himself will be tortured, end quote. What is then, though? I will again note that the BIA's recent case law seems to be saying that literally nothing except an applicant being deported and tortured and then, I guess, reporting back on it will suffice to satisfy the cat. And even then, maybe that too would be insufficient factually. What am I missing here? I mean, guys, it's a 51% burden. And also, what is the relevance of paying a bribe to avoid torture? Is that what the cat requires? Been arguing that one for a little bit now. Moving on through the findings that Mr. WF was at risk of torture by gangs or a vigilante mob. But you know what? Quote, generalized evidence that mass atrocities have happened in an area that the respondent might move to is insufficient to establish that it is more likely than not that the respondent himself will be tortured there. End quote. The evidence must be specific to a CAT applicant, explains the BIA, which of course was clearly presented here, specific evidence. The BIA just says it wasn't specific enough, I guess. In any event, the BIA doesn't believe that torture will occur with the consent or the acquiescence of the Haitian government, particularly as it summarily rejected that prison-based claim. And that claim has the strongest government connection, right? Despite the IJ seemingly finding that the Haitian government is essentially at war with gangs in Haiti and is far from winning, quote, generalized evidence of government instability is insufficient to meet the respondent's burden to show that the Haitian government would consent or acquiesce to his torture, end quote. So framed, that's about it. Mr. WF is going to Haiti. And that is a matter of WFs. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Matter of JCAG, published by the BIA. Told you, we got a lot this week. If you disagreed with that cat case I just did, wait till you hear this one. Naturally, the Attorney General decided to make it precedential because she loves it so much. Mr. JCAG was convicted of participating in a cocaine conspiracy and spent 30 months in U.S. prison. He's from Mexico. The president just pardoned someone involved in a cocaine conspiracy involving far more cocaine, I believe. But people are telling me that Mr. JCAG was not treated very unfairly. So he's going to get deported, and certainly not going to receive a presidential pardon. What he did do is cooperate with U.S. law enforcement against that drug cartel in Mexico. Not just any cartel, it appears, either. A Sinaloa cartel-affiliated one, it seems. An immigration judge granted cat protection, believing Mr. JCAG would be tortured and killed as a snitch in Mexico, and that the government consents or acquiesces to such things. Indeed, the IJ believed that Mexican police themselves were more likely than not to do it. Or I suppose at least one Mexican police person, as I understand, is sufficient under the Convention Against Torture. Having apparently never watched Narcos Mexico, the BIA reversed so as to ensure that Mr. JCAG is sent back to Mexico. According to the BIA, in this particular case, quote, there is not sufficient evidence in the record to show that anyone affiliated with the Sinaloa cartel is aware of the applicant or his cooperation, or that he ever received any threats or harm from the cartel. The conclusion that the cartel will expend resources to hunt down and torture the applicant upon his return is speculative, end quote. Matter of JFF strikes again. As it did in the last case too, like always, of course, I just didn't mention it. That's it on the Sinaloa cartel. One sentence. Regarding corrupted Mexican police, the BIA seems, I guess, to concede that the record shows that they target U.S. deportees who don't speak great Spanish, like Mr. JCAG, but that it was more about harassment and extortion and beatings and jailings, which isn't torture. Plus, the fact that some cops do bad things to people, only some, is generally insufficient to the BIA to satisfy the cat. Again, going back to this BIA-created world where people who aren't actually first tortured appear to have very little shot at winning before the agency. They'll just always call it speculative. And as one circuit recently found, right? Everything that you think might happen in the future is to some degree speculative. By the way, if Mr. JCAG can't speak Spanish, he's likely been in America since he was a very young child and knows very little about Mexico, right? Unstated by the BIA. Returning to the cartel stuff, not the larger Sinaloa one, but the actual cartel affiliate involved, I guess, the CJNG cartel. Well, quote, the applicant testified that a co-conspirator and fellow detainee, Ricardo, who was affiliated with the CJNG, told other detainees that the applicant was a snitch. Based on country conditions evidence and expert testimony concerning CJNG's operations and influence, the IJ found that CJNG already knows about the applicant's cooperation with authorities, plans to target him upon return, and will coordinate with other cartels to find and torture him no matter where he goes in Mexico, end quote. Which is exactly what expert testimony is for and permitted to do. Insufficient, said the BIA, without addressing really what the expert specifically said. To the BIA, it all kind of depends on Ricardo, and so, quote, the links in the evidentiary chain leading to the applicant's torture are too tenuous, end quote. Are you going to take that insult, Ricardo? Tenuous? Quote, we acknowledge the immigration judge's consideration of the country conditions and expert testimony, which paint a picture of near omnipotent cartels who can easily find and torture anyone in Mexico whenever they wish. But the requirements for cat deferral are exacting, and even appreciable risks of torture will not qualify unless they are more likely than not, end quote. Kind of a circular sentence that doesn't say much. And again, we're talking about 51%. To the BIA, it might have been different if Mr. JCAG, quote, personally received any threats or harm related to his cooperation in detention or in the several years after he was released from prison, end quote. I'll conclude by just quoting the BIA's conclusion in full, quote, the applicant may face some risk of torture resulting from his participation in a potentially cartel-related drug trafficking conspiracy. But the record before us, ultimately predicated on jailhouse hearsay and absence of any actual threats despite ample opportunity for their issuance, is insufficient to establish a clear probability of torture, even considering the general evidence that the cartels operate in many areas of Mexico with impunity, have corrupted many government officials, and inflict significant and serious violence on Mexican citizens, end quote. Emphasis by the BIA. And that is a matter of JCAG. Finally, we have matter of Dubon Miranda, published by the BIA. Rounding out the BIA's December to Remember sales event, we have a case about Bond. Mr. Dubon is from... Oh wait, how silly of me. The Attorney General decided to make it precedential because she loves it so much. Alright, back to the case. An IJ granted Mr. Dubon a $7,000 bond. The BIA is ordering him detained again. Quote, in bond proceedings, respondents bear the burden to show they are not a danger to the community or such a flight risk that no bond amount would be sufficient to secure their appearance. End quote. A rule DOJ made up long ago and which is generally not how the U.S. understands the incarceration of other human beings in America. Mr. Dubon was charged with third-degree sexual assault of a child on September 28, 2022, and 2 counts of third-degree sexual assault on a child in July of 2022. Also, it appears he is here without authorization, the BIA notes in a footnote. But it seems all of this predates matter Furtado, and the BIA is just not getting into it. Careful listeners will note that the actual criminal court doesn't believe Mr. Dubon's so dangerous that he can't be released back into the community, right? The non-criminal court BIA has other plans, namely, detention plans. After all, it is alleged, but not yet proven anywhere, that Mr. Dubon did some creepy things to his stepdaughter when she was a child. Oh, I take that back. The charges were actually dismissed. So the criminal justice system has made its decision about Mr. Dubon. And the stepdaughter took back her allegations about being physically touched. But the allegations never proven anywhere and which were dismissed also included allegations that Mr. Dubon sent his stepdaughter inappropriate text messages. And the IJ believed that Mr. Dubon once entered the stepdaughter's bedroom while drunk and behaved inappropriately and possibly sexually. Quote, such behavior is highly indicative of being a danger to the community, end quote. Plus, he did eventually plead guilty to 2 counts of disturbing the peace related to the stepdaughter and seemed evasive when asked by the IJ about what he actually did. Quote, these criminal convictions are also indicative of his dangerousness, end quote. Plus, a DUI in 2010 explains the BIA. Given all of this, and the fact that non-citizens have the bond burden, unlike U.S. citizens, the BIA vacated the bond grant. I don't know, guys. It does seem to me that the dangerousness finding depends, factually, on that drunk bedroom event and the fact that he's actually convicted of something. But IJs have so much power during bond, so your guess about how decisions like this and all the other ones will play out for other non-citizens is as good as mine. Quite the week. And that is matter of Dubon Miranda. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Aww. Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.